waste of public assets, causing a loss to the public exchequer and consequently the people. In this regard, one reference can be made. The court took notice in suo motu action regarding maintenance of foreign currency accounts in the year 2018 and made the government aware of the lacunas in the laws which allowed unregulated outflow of foreign exchange from bank accounts in Pakistan, thereby encouraging the government to make appropriate amendments to the amendments. These were indeed introduced by the government in the Income Tax Ordinance of 2001 in the tax year 2018. Ladies and gentlemen, by taking all of you on this journey to visit some of the landmark judgments delivered by the court, I have attempted to give a brief but overarching view of the court's prior efforts to uphold different aspects of the rule of law in the country. However, it is a shared belief in the judicial community that if we are to truly progress as a nation, which is fully committed to the ideals and aspirations of the Constitution and the rule of law, then all stakeholders in the justice sector need to rise to the challenge. The judiciary cannot pursue these ideals single-handedly. The other organs of the state, namely the legislature and the executive, must also adhere to constitutional principles and ensure that their actions advance rather than negate the ideals and aspirations of the Constitution. Additionally, the executive must also be diligent in implementing decisions of the court, especially in matters of constitutional importance, without undue delay to truly anchor the rule of law in the country. The court has the power to declare the rights guaranteed to the people by the Constitution and the law, but it cannot implement the same except in very limited circumstances. Therefore, it is the executive which must take charge in this field and ensure that the words of the court are translated into practical action for the people. The bar is also expected to join hands in delivering justice where it is most lacking by making the courts or other fora of dispute resolution accessible to people who cannot access these due to reasons of poverty, marginalization, and illiteracy. The culture of filing frivolous cases must also be curtailed so that genuine grievances of the people are addressed. Where the filing of such cases is observed, cost should be imposed on litigants to ensure an efficient and effective functioning of the court system. On our part, concerted efforts are underway to reduce the backlog of cases to ensure that justice is delivered inexpensively and expeditiously to litigants. Briefly, some of these measures are as follows. Encouraging litigants to make use of alternate dispute resolution mechanisms to amicably resolve their legal disputes. 2. Frequently hearing cases through video link, digitalization of the judiciary, thereby reducing the cost incurred by the litigants as well as their counsel. Prioritizing early release of cause lists. Giving priority to hearing regular matters. Fixing special matters after normal court hours. Maintaining the continuity of benches so that part-heard cases may be decided. And, of course, finally, to have a brilliant case management committee comprising illustrious judges like Justice Mansoor Ali Shah and Justice Munib Akhtar, with whose efforts this court has, for the first time in 10 years, ever since our computerization of caseload was started, first time we have managed to reverse the trend of increasing backlog. Inshallah, we expect that once the shortage of judges in our court, which is almost 1/3 of its strength, will further improve our performance. Our target 6 months ago was to come below 50,000 cases at the start of this judicial year. Unfortunately, we've missed the target by 173 cases. Which is all right. The larger issue of backlog lies not at the court's doorstep, but the district level, where around 1.7 million of the approximately 2.1 million cases pending in the country are awaiting adjudication. Under Article 203 of the Constitution, it is the duty of each High Court to supervise and control all courts subordinate to it. Therefore, they are expected in the liaison with the National Judicial Policy-Making Committee to devise strategies to equip the district judiciary with the necessary tools to ensure swift and substantive justice to the people. To achieve the objective of dispensing substantive justice, the court is fully aware that the task of tweaking the law purposively lies with it, because the district and district courts and the high courts are bound by the Supreme Court precedents. At present, our criminal legal system has a low conviction rate due to poor investigations and a heightened focus on procedural technicalities. Therefore, to bring a balance between the rights of the accused and of the victim, it is the court's duty to re-examine the principles of criminal law and recommend changes where necessary to ensure a society free of crime and disorder. Similar efforts to the people. To achieve the objective of dispensing substantive justice, the court is fully aware that the task of tweaking the law purposively lies with it, because the district and district
नेस्ले बुनियाद नए आयरन प्लस के साथ जो है 3 गुना ज्यादा मौसर।
एक रोशन सुबह आई है।
नेस्ले बुनियाद आयरन प्लस, बेहतर जिंदगी की और भी मजबूत बुनियाद।
क्या आपका निखार खो गया है? नहीं, सिर्फ छुपा है डेड स्किन सेल्स के नीचे। नया पॉन्ड्स ब्राइट ब्यूटी फेस वॉश, इसका स्पॉट रिडक्शन फॉर्मूला डेड स्किन सेल्स को क्लियर करे और नई सेल्स को उभारे, ताकि आपका निखार साफ झलके। पॉन्ड्स ब्राइट ब्यूटी फेस वॉश, पाएं स्पॉटलेस स्किन हर दिन।
क्या हुआ?
स्कूल में लड़कियों ने तंग किया।
बैठो, ये देखो तुम्हारे बाल, इन्हें खींचो, मड़ोड़ो, तंग करो।